The Supreme Court has set aside a 2007 National Consumer Dispute Redressal Commission's order, which capped interest rates at 30% for default of credit card dues. A bench of Justice Bela M. Trivedi and Satish Chandra Sharma overruled the order, giving more flexibility to banks. Ashmit Kumar joins us with the latest. Ashmit, what did the court say?
Well, the Apex Court giving a very clear answer that going forward, banks, whether Indian or overseas banks, will be at liberty to charge a fee that they believe is relevant and applicable as far as default on credit card dues is concerned. Now, all of this issue, this entire debate and discussion travels back to 2007. The reason being that is when the national NCDRC, the National Consumer Redressal Grievance Forum, had in fact come out with a ruling which had capped these penal charges at no more than 30%. Now, this is something that caused a great deal of concern within the banking community. The likes of HSBC, Standard Chartered, Citibank, they had moved the Apex Court, requested for a stay. In 2009, the Supreme Court granted a stay, but the larger question on what really happens on the way forward from here remained. That big question mark has been answered by the Apex Court. The Supreme Court saying that, yes, indeed, there is a case made out by the banks. They can go ahead and charge penal rates, that these penal rates are computed, keeping in account all the cost components involved as far as banks are concerned and as far as banks are extending credit services are concerned. So with that in mind, the Apex Court answering this question in favor of the lenders. The rates can now go up to as high as 49%. Back to you.
All right. Thank you very much, Ashmit, for joining us with that important case. Moving on to cybersecurity.